A little after 7. Sorry about that. 7:05. We doing this live tonight about the Bond County real estate tax situation that's going on. We did a presentation last night to a couple hundred people at the Farm Heritage Museum. Then we went up to the we went up to the county courthouse and listened to the assessor and the clerk and the treasurer give a little presentation. That presentation wasn't very informative. It actually, for the most part, was not even relevant to the issues facing taxpayers in Bond County at the moment. I've made it clear all along, I'm not disrespecting any of those ladies. I know all three of them. The assessor and I went to high school together, but you know what? She's an elected official and she's not doing her job right, and it's harming people financially in a significant way. I'm going to help people and going to get involved. And if she doesn't like that, then, I don't care, to be honest with you. But, it's just the way it is. This is not a gun ban case issue, Jason. This is about taxes, and we'll deal with the gun stuff later, okay? The answer is no. There's no update. And you can call Dan Calkins and ask him about that because he's delaying things. But I'll deal with that later, Jason. So I wanted to do this presentation for people about what is going on in the Bond County real estate tax issues, and then about what their options are of how they might be able to deal with that. Because there's a lot of people in certain parts of Bond County whose tax assessments have changed dramatically. And if all things continue to play out, they could see their tax bills go up several $1,000s a year. You're welcome, Jason. So there's three different things, as I said last night, that people need to kind of understand. The first one is it deals with the Board of Review. It's kind of a collateral issue, but it's an important issue as it relates to your assessments and what you're going to do. So go ahead and switch the slide to the first one, if you could, Ryan. Okay, there's a few terms that I want you to understand as we talk this through that I think are important. And again, the real estate tax system in Illinois, it's so complicated that most citizens don't understand it. And again, that's not a criticism, that's just reality. Most lawyers don't understand it, to be honest with you. And finally, I'll say that most assessors don't even really understand the complexity of the whole thing, all right? So here's a few terms that I want you to understand. Fair market value. Fair market value means your real estate, what's it worth if somebody's going to buy it from you? In an arm's length transaction, two disinterested people being interested in buying and selling, what might it bring on the open market? It's not an exact science, but it's certainly something that has to be established. And you think of it maybe many times as an appraisal. What's my property really worth? It doesn't mean you can sell it for that. You might sell it for more, you might sell it for less. But what is it reasonably worth on the open market? Your assessed value is not the same number. Under Illinois law, the assessed value is 1/3 of the fair market value. So if your property is worth approximately $150,000, your assessed value would be $50,000. Okay, so that's important for you to understand. A tax levy. A levy is the amount of money in hard dollars, 1, 2, 3, 500, $1 million, is the amount of money that a taxing district asks to support their political agenda. So your school asks for money to support the school. They issue a levy, and how that's collected we'll talk about in a second. Your county board, your fire protection district, your cities that you live in, all of these taxing bodies will issue a levy every year saying we need this much money. Go collect it from the taxpayers that live within our jurisdiction. The extension rate, when you look at your tax bill each year, you'll see a rate on the bill. Depending on where you live, it could be $7 to $9 per hundred rate. So that number on there. That number is merely a calculation. It doesn't say a whole lot other than this is your total bill. This is how much your property is assessed at. You divide that number, it gives you a rate. Rate cap limit is an important one for you. A rate cap limit is something set by state law that says certain government bodies for certain types of funds can only ask for a certain percentage of assessed valuation. And I'll get to that in a minute. One of the biggest ones that taxpayers should understand is your school and its education fund, which is the primary fund for your school district. It's limited by state law at 2.2% of the assessed value of the school district. So if your school district has $500 million aggregate assessed value of all the properties, then $11 million is the most they can ask for. They can't ask for more because that rate limit caps them out. Okay, that's important for you to understand. Go to the next one, Ryan. Okay, taxation, the most important thing about taxation comes from the Constitution, deals with uniformity. And I just saw another one pop up on the gun ban. If somebody asks me another question about the gun ban, I'm going to block you from this video. I'm not talking about guns right now, so please, it's not the day. Move on. Real estate taxation, the most important thing is uniformity. It's in the Constitution, Article 9, Section 4, that says real estate property has to be uniform, which means everybody gets treated the same based upon some driver. And the driver that we have under Illinois law is the value of your property. So if you have a property that's similar in value to your neighbor, you have to pay the same amount of the tax. You can't pay more than your neighbor if your properties are valued the same. That's uniform. It's fair. It's equal. That comes from the Constitution, and the laws that are passed by the legislature in Illinois have to drive the requirement of uniformity. And they do as the law is written. As it's applied by some county officials, and that's kind of what we're talking about here in Bond County, which is not uncommon for other counties, is whether the practices of your assessor are actually conforming to the uniformity provision of the Constitution and of the state laws of Illinois. Okay? Go to the next one, Ryan. In your county, you have your county assessor, who is in Bond County is elected. It's Miss Georgia Shank. You also have township assessors who work at each township in Bond County. We have 9. Those township assessors and your county assessor are supposed to create the assessments for everybody's property in the county, and they do it fairly and uniformly and consistently across the spectrum. That's the simple way to put it. Then you also have the Board of Review. The Board of Review is a 3-member board that's appointed by your county board, and they're kind of like, they hear the appeals. So when you do get an assessment from Georgia in our county, if you don't agree with it, you can go to the Board of Review. The Board of Review will hear your complaint, and they'll make a decision whether to agree with you as a taxpayer or to agree with Georgia. And then there's other steps above that, but we're not going to talk about those right now. The Board of Review is, again, created by Illinois law. And there's something important you need to understand about these appointed persons on the Board of Review. And if you go to the very last sentence of this part of the statute, it says, no person may serve on the Board of Review who is not qualified by experience and training in property appraisal and property tax administration. So they have to have both experience and training. And why that's important is because many counties don't follow this, is you get people appointed to the Board of Review that have no idea what they're doing. And what ends up happening is when they sit on this Board of Review, they are influenced by the assessor who they think has more knowledge and experience and training than them. So, and taxpayers many times don't understand some of these intricacies. And if they haven't hired a lawyer to help them, which they certainly don't have to, the Board of Review will end up just listening to the assessor because they don't really know what the heck they're doing. That's why this is in the law. Okay, it's very important, and taxpayers should make sure that these appointments to the Board of Review are by people who are qualified and trained, as this says. If the taxpayers don't pay any attention, you get incompetent people who are ignorant to the law and the process appointed, and then when it's your time to appeal, you have a Board of Review that's not properly constituted of people that should be hearing these appeals. Go to the next one, Ryan. Okay. Before I get to this one, I want to tell you, now the Board of Review in Bond County had a vacancy recently. They needed to appoint a new person to the Board of Review. And the gentleman that they appointed has no experience and no training of any kind whatsoever in property tax appraisals or property tax administration. Zero. Again, not being disrespectful to this man. I don't know him. I'm sure he's a great guy, but the law says he can't be on the Board of Review. But yet they appointed him to it. One of the issues that I'm going to raise, because I'm a taxpayer in Bond County, I'm going to raise it myself. It doesn't really take a lot of people, is that this person can't be on the Board of Review because they're not qualified under the statute. And I would like to see other taxpayers raise this issue as well, because if you don't, then these things are going to continue to happen in the future. If I can fix this now and they find somebody who's qualified, great. But what about a year, 2, 3, 5 years from now? So you know, if you're asking questions in Bond County, you should ask, why do we appoint somebody that's not qualified? They'll try to tell you, here's what they're going to try to say, because these elected officials in our county, like many, rely upon the ignorance of the taxpayer and just blow smoke. Well, he's got a year to get some training. No, he doesn't. There's a fly following me around. I apologize, you guys. No, he doesn't. There's a provision in the law that says if your county has over 100,000 people in it, that a person appointed to the Board of Review can be required to take an exam. Bond County only has 20,000 people, so this provision of the law does not apply. But you do have to have the requisite training and experience to even be appointed under any set of facts, whether you have to take an exam or not. So what they're saying to you is a complete mischaracterization of the law, 100%, but they're going to try to tell you that. And so what you should do if you're going to go ask this question and they try to blow that smoke, say, can you please show me in the law where it says that this person can be appointed right now with no training, no experience whatsoever, and then they got a year to take a class? Where does it say that? Because I'm here to tell you with 100% certainty, the law does not say that whatsoever. Okay? That's what you need to understand about the Board of Review and what's going on in Bond County and why they're doing these things. And they're doing them because they think the taxpayers are stupid and that they'll get away with it. And, oh, we've always done this. It's ridiculous. You know, sadly, and I'm not being disrespectful, the state's attorney in Bond County should have stepped up and told the county board, you can't make this appointment because this person doesn't conform to the statutory requirements. That was not the advice the county board was given, in my opinion, and from the best I can tell. Okay, so now let's talk about how the assessment process works. There's two things you need to understand about assessments. You have a general assessment year, and you can see the provision of the law that Ryan has up right here. General assessment years, and then you have non-general assessment years. And your property can only have a general reassessment one time every 4 years. Let's assume that you have not made any additions, you've not built anything new, etc., because that's a change. We're not talking about changes. Under normal circumstances, your property can only be reassessed to market value every 4 years. Okay? When is that 4-year time frame? It's very important for you to understand. When is the 4 years? Because I, as a taxpayer, need to know when my property might be reassessed. So if I want to object, I can. This provision of the statute says right here, it's every 4 years, beginning in, look at that, 1995. Less than 3 million inhabitants. Why do you see in our laws sometimes less than 3 million, over 3 million? It's because Bond County or Cook County sometimes gets different treatment. And that's not necessarily a bad thing because they have a lot of people. Bond County's less than 3 million. So in 1995 was the first year that Bond County was subject to general reassessment. And then every 4 years thereafter, which would make it 2023. So the year we're in right now, absent some change, would be a general reassessment year for Bond County, the whole county. There's another provision in the law that says a county board, if it does it properly, can change from this 4-year cycle for the whole county, okay? And that's this provision of the law. What this says, I'm not going to read the whole thing to you. It says is a county board can by resolution, which means they vote and pass a resolution, that says we're going to switch, and instead of doing the whole county every 4 years, we're going to do, simply speaking, 25% of the county each year and break it across 4 years. Okay, does that make sense? It breaks it apart so there's less workload. Instead of trying to do the whole county in 1 year, or in 1 year in 2023, we're going to do 25% a year by township. The law says, state law says, you have to, by resolution, break the law into 4 assessment districts and make them as close to equal as possible. Make sense? And you have to do it, that damn fly, you have to do it by township. You have to break it apart by township. It says it right in the law. You can read it, okay? In 2020, the Bond County Board, which is the old board, the new board that you have in Bond County, the only person left on the board today that was on the board then is Mr. Wes Porshow. Mr. Porshow is the only remaining board member today. The other 4 are all new. But back in 2020, you can see the 5 board members that you had on your county board that signed this resolution attempting to break Bond County into assessment districts, saying we're going to do 25% a year. This resolution is 100% unlawful. At the county board, at the county meeting last night, the assessor admitted that this resolution was wrong and it wasn't done correctly. Okay? The reason it wasn't done correctly is because you can see by looking at it is it doesn't break the county down into 4 assessment districts. It doesn't give you, the taxpayers, notice of when is my township up for reassessment. Because what it should have done is said assessment district 1, we're going to do in 2020, and it would be Mills Township, LaGrange Township, Old Ripley Township. And then the next year is going to be Burgess Township and Central Township. And that way you as the citizens would know, okay, this year is my township subject to general reassessment. Because when they didn't do that in this resolution, it doesn't let you as the taxpayers know anything about when's my turn. So that's why the county has this resolution that's not legal. It's not lawful. And again, Georgia, your assessor, pretty much admitted that last night in the board meeting. It's that they know it's wrong and that they're going to have to go try to fix it. Well, I'm sorry, you might be able to fix it for into the future, but you can't fix it for the last 4 years. What did you do the last 4 years, Miss Shank? How did you decide what townships in 2020, 2021, 2000? Did you just kind of wave a magic wand and say, I'm going to do this township or that township? Miss Shank even admitted that she broke Central Township apart and was trying to do part of it in each year, which the statute says you can't do. So there's a lot of problems with the attempt to turn Bond County into a quad reassessment, quarter quad it's called, okay? I think they've got huge issues with that, and it's going to impact the assessments that are going on right now significantly, all right? Go to the next one, Ryan. Okay, so how do valuations and general reassessment years work? Okay, whether you're doing the whole county in the whole year in 1 year, or you've switched and you're going to do a quarter of the county each year over 4 years. Doesn't matter which way you're doing it. When a piece of property such as yours is subject to general reassessment, where they might change your property, adjust it for a market value specifically to your property. This is the part of the law that says they have to do a couple of things. By June 1st of that year, of the general reassessment year, they have to actually, and I'm going to show you in person, actually view your property. Guys, they don't do that. They absolutely don't do that. They'll try to tell you that they do, but ask them for their notes. Say, because they take, when they do it right, they take field notes, okay? They take notes about where they went, what property they looked at, what they saw, etc. Ask them, let me see the field notes for when you viewed my property. What day did you view my property? I promise you, with a high degree of certainty. They don't have that. They don't do it. They just don't do it. Now, do they go and view some properties on occasion? Certainly. But do they, as a matter of procedure, go and do that? No. Let me give you an example. When we were at the county meeting last night, a former assessor of Burgess Township tried to say, we viewed every property in Burgess Township in 9 days, 8-hour days, 9 days. How many hours is that, folks? That's 72 hours. Okay. We viewed every property actually viewed in Burgess Township in 72 hours. Folks, there's 1,500 to 2,000 parcels of property in Burgess Township. That's about 20 something to 30 properties an hour that this gentleman was trying to say they viewed. It's bull crap. They didn't do that. Okay. So, but anyway, the statute says they have to do that. Okay, let's move on to what else the law says. Go to the next one, Ryan. Okay. Now, values in years other, before I get to what the general reassessment year, what about in non-general reassessment years? See where it says in the statute, valuation in years other than general reassessment? They can make changes in non-general reassessment years, but they have to do it categorically across the whole county or assessment district, like an equalizer or a multiplier. Okay, that's what they have to do. They can't, in non-general reassessment years, go out and start doing fair market value analysis of your property or other people's properties in non-general reassessment years. They cannot do it. Now, if you make an addition or you add something or build something new, they can then, in non-general reassessment years, bring that up to speed. But absent any of that, they can't make market value changes to your properties in non-general reassessment years. They can only add equalizers and multipliers. Okay, go to the next one, Ryan. And this talks about the equalization that I just told you about in non-general reassessment years. They can apply equalizers in townships, types of properties, etc. So far too often, your assessor will apply an equalizer across the whole county, which has a ton of, remember the word I told you, uniformity problems? It's beyond the scope of this little presentation, but just let you know, when equalizers start happening, people should pay particular attention, because equalizers can create a lot of unfairness and a lot of lack of uniformity, but we'll save that for a later date. Okay, go ahead, Ryan. Okay. This is the third issue that we have in Bond County right now that is huge. This issue, the first two issues that I told you about that had to do with the Board of Review member and that resolution that I told you about, those first two issues is where I initially started on this path in Bond County, that I was going to find 1 or 2 or 3, property owners in Bond County to join with me to deal with that resolution and the Board of Review member, because it doesn't take individual participation in order to protect you. That issue of those two can be dealt with on a mass scale by just a couple of property tax owners. This issue that I'm explaining to you right now would require the individual participation by you as a taxpayer in order to protect yourself. The other two issues don't require your participation, and if I and 2 or 3 other taxpayers take that on, you could get the benefit of that. But this issue about publication and notice is specific to each of you, and each of you would then need to decide how you want to proceed on this issue. Okay, let's talk about this. Publication of assessments. If your assessment is going to change from the prior assessment for fair market value, they have to give notice. Give you timely notice. Remember that, timely notice. What is timely notice under the law? Timely notice under the law says by December 31st of the general reassessment year. And if you read in there, that's what it says. I'm not going to ask you to turn into lawyers and read section 12-10, but what it says to you, I'm telling you, is whatever general reassessment year you're in, they have to publish that notice and give you notice of your change in assessment by 12/31 of that year. And if they don't give you that notice on time, the law in Illinois says that the notice is not valid and they can't raise your assessment based upon that fair market value change that they're trying to propose. It's what the case law in Illinois says. The Illinois Supreme Court said it in 1976. I've got the case law, okay? So the question for you is did the publication that you got properly comply? Okay, let's look at this. See this notice to taxpayers right here, guys? Ryan, highlight where it says publication is hereby made under that second, in accordance with 35 ILCS 20/12-10. Can you highlight that? Is it even possible? Okay, maybe you can't highlight, guys, but read there. You see where it says under the second paragraph, publication is hereby made for equalized assessed valuation for real estate property in this county in accordance with 35 ILCS 200/12-10. Do you see that? What does 35 ILCS 200/12-10 say? Back up, Ryan. Where does it go? Okay, look at the second to last sentence. The publication shall be made on or before December 31st of that year. Go back to the notice. That notice was published in the newspaper on January 23rd of 2023. 6 months too late. That notice was published. Now, in my professional career, I've never seen this level of, I don't want to say incompetence. That's because that's being, I'm not trying to be disrespectful. I've never seen that to where they're 6 months late. And guess what? The state law in Illinois there's a case from 1976 where the assessor was only 1 month late. And the Illinois Supreme Court said your notice is defective. You can't raise it based on fair market value. Now, what's important about this argument that I just made to you is that in order to protect yourself, you're going to have to go through the appeal process and potentially go into the court system in Bond County. It's going to require more than just going and complaining to Georgia, probably. It's going to require you to probably sue them or to do an appeal correctly, okay? The first two issues I've explained to you, you'll probably be fine by just sitting back. If this is an issue you want to take to where that notice that you got in the mail on June 23rd, and then you're going to get a new one because those were messed up. If you want to protect yourself for that under the legal analysis I just gave you, you're probably going to have to file a lawsuit or get somebody to help you with that, okay? And again, I always make sure I'm clear. You want me to help you? That's a separate conversation. On this issue, you'll decide that later. Go on, Ryan. Okay. This is some of the case law that I've thrown in here. I'm going to skip over it pretty quick. That pretty much says that the assessor can't treat you guys differently if they're trying to ratchet you up and not other people. They can't treat you differently. Lack of uniformity. All of this case law deals with lack of uniformity. Okay? And go ahead, Ryan, and flip past them. Okay, go ahead. So that case law is important. And again, you don't have to understand it today, but just remember what I told you. Uniformity and treating you fairly like all of your other taxpayers. Because here's what happens. Before I get to these examples that I've given you, here's what the assessor will always try to do with you. And I'm here to tell you is bullshit. You go in there and you say, okay, I want to complain about my taxes. They went up. Well, how much do you think your property's worth? They'll say. And you say, $150,000. I think my property's worth. Well, we've only got you assessed like it's worth 110, so you're catching a break. What are you complaining for? Don't complain. That's not even the legal question. The legal question is not whether you have a property that's worth more than you're assessed at, but is it uniform and fair for everybody? And this first example that I'm giving you here will explain that to you on how the response that you'll usually get from them is BS. Now, there's 15 to 16,000 parcels of property, total parcel ID numbers in Bond County. The analysis of showing you some of these things with that many parcels would be so convoluted, you wouldn't appreciate the legal theory and the equity and the uniformity. I've given you 8 parcels in the whole taxing district. The logic is exactly the same, but I'm only going to apply it to 8 properties because then it'll help you make sense of it, okay? So I have 8 properties in my whole assessment. It's like, pretend that's Bond County, all right? And everybody has a property that's worth $150,000. Now, the law in Illinois presumes that your ability to pay your share of the property tax is driven by the value of your real estate. So what that means is that if you live in a $150,000 house and your neighbor only lives in a $75,000, let's assume it's really a $75,000 house, you should pay twice as much as them. Because the law presumes if you can afford a house that's twice as more valuable as your neighbor, that your station in life or your position in life is such that you should pay more, double the tax burden than your neighbor. So you've always heard, oh, I built a new shed, Tom, and my taxes went up $4,000 a year just because I built a shed. Again, the law presumes since you were able to build that shed, that in general, your life is such that you can pay more of your share of the taxes. I'm not saying I agree with that philosophy or that policy, but that's the policy in Illinois. Value of your property drives your share of the real estate tax burden. So in our example here, initially, we say all 8 of these people live in the exact same value of house. Now you can see AV means assessed valuation, and the law says it's supposed to be a third, but look here, it's not a third. A third would be $50,000. These property owners are underassessed. Now, but look, they're all underassessed exactly the same amount. So they are equally or uniformly underassessed. So there's no violation of fairness to the property taxpayer because they're all assessed the same way. So you see where the total assessed valuation is $200,000. 8 houses at $25,000 a piece. So the total value of this whole taxing body is $200,000. Now I'm going to give you something important here. If all of the taxpayers here are treated exactly the same, is there a complaint to be had about assessments? And last night when we did the presentation, the taxpayer said, no, we don't care. We're all treated the same. Nobody complains. Wrong. You know who complains? The taxing districts complain. The reason the taxing districts complain is because they want properties assessed as high as possible because it impacts how much money they can ask for them for the taxpayers. Remember when I told you value of property dictates your ability to pay? The taxing districts want every penny they can get for the most part. And again, in Bond County, I'm not here to throw people under the bus, but the superintendent of the Bond County School District is going to levy every penny he can levy from the taxpayers. It's just life. He's going to do it. If you don't like that, get a new school board and get rid of him. So remember when I told you rate cap limits? You see here the 2.2%? That is the rate cap limit of the education fund in Illinois by default for your school. So with a $200,000 assessed EAV, the maximum levy of the school district's $4,400. They can't ask for any more. That's $550 each. So each person's paying the same amount. No unfairness or no lack of uniformity, but the school district's pissed because they're limited to $4,400 because they need that 2.2% ceiling. They need it to go up. So every year, mark my word, your superintendent of your school district is calling the assessor wanting to know how much assessed value is going to increase because they want to drive her home, baby. They want every penny they can get. And so they're on the phone all the time. What's it going to be? What's it going to be? What's the assessed value going to be? Because then we're going to go to the next slide, and I'm going to show you why that is important to the school districts primarily, but every taxing body. Here's my same example. Now see here, the houses are all still worth the same. And now everybody's assessed values at $50,000 instead of the 25. Now they've all been raised up to $50,000. So there's no lack of uniformity. Everybody's being treated fairly. And now what's going to happen to their tax bill? Remember, under the prior scenario, the tax was at $4,400 because that 2.2% rate cap was hit. But just because the assessed value goes up doesn't mean automatically that your tax bill is going to go up. It means that your taxing districts might ask for more money that might make your tax bill go up. You with me? Because if the same $4,400 that your school district got in my scenario last year is all they asked for this year in this scenario, it's still $550 a person because you're only going to collect the $4,400 that they asked for across these 8 taxpayers. However, your superintendent in our scenario will go, oh, great, assessed value is going to go from 200 to 400. I'm going to take the 400,000 times the 2.2%, and now I'm going to ask the taxpayers for $8,800 instead of $4,400 because I'm going to get every penny out of them I can get. Now your tax bill is going to be $1,100 instead of the $550. At least there's no lack of uniformity, but your taxes went up because assessments went up, and the taxing districts are going to take every nickel. And 9 times out of 10, every taxing district at every level is going to take every nickel. That's why they're all, and again, I'm not picking on anybody, but your municipalities, your school districts, your county boards, they're all calling the assessor, barking in their ear, how much is the assessed values of these properties going to go up? Let me give you an example of why that's what they do. Remember, for those of you that are old enough, back in 2006, 2007, 2008, when we had the real estate crash and properties just went through the floor, how many of you remember your tax bill going down? It freaking didn't. You know why? Because the assessor wasn't out there lowering the tax or the values of properties. You know why they don't? Let's say, for example, go back to my other scenario, Ryan, before this. Go back, Ryan. See this scenario here where properties are worth 150, they're assessed at 50. Let's say everything's good. Your school district's levying that $8,800, guaranteed. They're going to go to the rate cap limit. Let's say next year, the market values of your properties drop because the market collapsed, and fair market value of all of these properties fell to $75,000. The values fell in half, and the assessor drops the assessed value by half. Your school district can no longer ask for $8,800. The law would say they can only ask for $4,400, so they would lose all of that revenue. Guys, if that happens in reality, your school district's going to go bankrupt. The reason they're going to go bankrupt is because all of the union contracts that they negotiate, where they're putting in pay raises and pay increases, etc., and that's a different conversation for a different day, puts a financial burden on these school districts that if they start losing this revenue from the taxpayers because market values decrease, you're going to bankrupt these taxing bodies. So that's why back in 08, 09, 07, you didn't see assessed values fall through the floor, because it would have been chaos for these taxing bodies. So you kept paying the same, and you might have saw no increase. You didn't see decreases, because once they're taking that money from you, they ain't giving it back. Even if that means the political pressure on your assessor to not reduce globally assessments because of market collapses, that's what they're doing in the background. Traditionally speaking, these taxing bodies are hammering for increases all the time. That's why you see what you see. And that's kind of with what's going on in Bond County right now. Go on, Ryan, back to where we were at. Okay, here's one that reflects a little bit more realistic of a lack of uniformity. I'm now into the lack of uniformity. You see here, I've still got my 8 houses. They're all still worth $150,000 a piece in reality. But the assessment of the top 4 is only at $40,000. They're under assessed, right? Because 40 times 3 is 120. Those 4 properties are under assessed. The other 4 property owners are assessed fairly. What does that mean? Okay. And if your proposed levy from your school district is $4,400, we'll just leave that the same. Your people who are under assessed are paying $880 of that. And the people that are assessed fairly are paying $1,100. You with me? So what happens is Those that aren't assessed at the right amount are catching a break, and the ones that are assessed fairly are paying more than they should. So let's say you go into the assessor and you're one of these $50,000 people, and they go, well, we don't know what you're complaining about. Your property's worth 150 and you're assessed at 50. Well, the problem is that all these other people are assessed at 40 because you didn't do your job right. And that's not fair to me. Now, that sounds easy, as an easy argument to make. Sometimes it can be pretty complicated to put that argument together. But that's one of the lack of uniformity issues that you guys need to understand, because uniformity means two things. One, that like properties are actually measured correctly. And two, you're using, this is very important, you're using the same methodology for everybody. So how are you driving fair market value for everybody? You can't say, well, we're going to look at this subdivision, or we're going to look at this lake properties on the lake because we think they're really going up and we're going to fix them. But the rest of the whole area, you don't even go look at it because you don't have time. You're too busy. We don't have enough people. So you're all fair market value. The rest of you, we'll just throw an equalizer on of 3, 4, 5% because we don't have time to get to you. Guys, that's happening all the time. It's happening in every county in the state. It's happening in Bond County, guarantee it. And that violates uniformity. If you're using market value for me, you got to use market value for everybody. No exceptions. Go to the next slide, Ryan. Here's what is even more realistic. All of our properties are still, again, hypothetically, and this is an oversimplification, but you'll get it, 150,000 property. But look at them. Some are worth 40, assessed at 40. Some are assessed at 20. I mean, look at this guy here. We got is assessed values 20. So that is presuming a fair market value of 60,000, even though he's worth 150. He's catching a huge break, right? But what about this guy in the bottom right who's assessed at 80,000? He's only worth 150. He's taking it hard. This is what's really going on in reality. If you look at the details, like dig into the nuts and bolts, not just Bond County, it's a lot of counties. I just sued in Coles County 2 weeks ago. They got it there too. You got people that are way overassessed. You got people that are way underassessed, all of the above, and it creates the lack of uniformity and unbelievable proportions. And how you go about fixing that lack of uniformity is complicated. It takes a lot of time. It takes a lot of effort. It takes a lot of money. And it takes an assessor that's conscientious about the realities of people. Because if you're going to fix assessments, you got to fix everybody in order to make it fair, okay? You got to make it fair. Because if you don't, people are going to be treated badly in a short amount of time. Let me give you an example. Let's say that your property is the $150,000 property. It's really what it's worth. And you're assessed like it's worth only $100,000. And you're catching a break. That's what they would say, right? But here's the reality. You have an escrow set up, and your life and your payments are such that you've been paying that for some amount of time. And in order to fix it, they cram it all on you in 1 year. And so they're wanting your taxes to go up $1,000, $2,000, $3,000 a year because of their incompetence and inadequacies for the last decade. I personally got a problem with that. But at a minimum, if they're going to do that to you, do it to every taxpayer in the county and take everybody up equally, uniformly, the same way. That's what you got to do. That's a good question, Steve. Was it done right last year? I'm analyzing that right now, but in my preliminary opinion, the answer is no. It wasn't done right last year because, again, they just don't have the time, the resources, all of the above. So no, I don't believe it was done right last year for a variety of reasons. So that's what's going on. You've got three issues, as I've told you about. You've got the issue of the board of review member who is not qualified. That's going to be taken on. You've got the issue of this resolution trying to break the county up into the quarter quads that they've admitted was illegal. That issue is going to get taken on. you as an individual taxpayer don't really have to be involved in those two things, because I have found 2 or 3 volunteers that I asked for that I would do that for, including myself, because I'm a taxpayer in this county. We got that taken care of. But this issue, this third issue, the fact that these notices that they've sent out to you saying we're going to increase your assessment, and you didn't get it until the first one until June of 2023, June 23 of 23, that requires you to individually take that issue on. Okay. I have filed a lot of these in Coles County. How many of you filed in Coles County recently? And typically what I've done is told taxpayers that I would do that for a flat fee. And at this point in time, I'm so frustrated in Bond County that I've decided to set that aside. And what I've offered to do on this third issue is for people, if they want me to prosecute this objection for them, whether it's at the Board of Review, whether it's in the court system, however it is, to prosecute, you didn't give me notice right. You can't ratchet my taxes up from that amount to this amount because you didn't give me the right notices, which again, these are solid legal arguments. I will do that for any taxpayer that wants to on a contingent basis. It's not going to cost you anything to file that case, to have me represent you, no court cost or filing fees. It's only going to be if I win the case, and I'm highly confident that we can win. I never say absolutely because I'm a lawyer. The case law and the law that I've read says the notice he got on June 23rd is defective. They had to give it to you by the end of the year. If I file that for you as well as other people and we win, then your assessment's going to go from what they want it to be down to a whole lot lower, like some people significantly lower. And that's going to then calculate and save you some amount of money, not only this year, but for the rest of your time of owning that property. So if you own the property of 20, 30 years, so let's say hypothetically, you do it or I do it for you, and your assessment goes down $30,000 assessed value. That's going to save you maybe $2,000 to $2,500 in the first year. And I would only say as a contingent basis that we split the first year 50-50. But the following years, it's all on you and it's all yours. So 50% only of the first year. And again, I'm not asking, I'm just offering if that's what you want me to do to help you. If you think you can take that fight on yourself that I've just explained in this video and go watch it back, I encourage taxpayers, jump in, go make the fight. Again, getting into the court system sometimes can be a little overbearing for people. They can get a little nervous, and that's okay. But if you want us to help you with that issue, and again, I think you got a really good chance, we can do that. Ryan's got a link, I think. He just posted it up there at the top. There's a link to where we need your information, and that I need your copy of the notice. Now, there's going to be two, because you got a notice on or about June 23rd. You're going to get a new notice. Sorry, guys, that fly is killing me. You're going to get a new notice of what they think they messed up. And you're going to get it probably next week. I'll answer this real quick in a second, Linda. And then I would need both of those, okay? How do we know the correct tax value? I'm assuming you're saying, Linda, the correct assessed value, okay? Well, you had an assessed value last year, the year 2000. We've got to go back 2021 because they've screwed it up. Whatever your assessed value was in 2021, they're now trying to take up to 2022, Linda. So if you look at that notice you got, they're trying to say prior year was this, current year is this. What I'm trying to do, and my argument would be, Linda, is we're going back to what the prior year was. We're going to start there. And from that, you only can maybe apply some equalizer or multiplier, depending on what that might be. But you cannot take me from the prior year to a current year based upon a fair market value analysis. There may be an equalizer of some sort, but we don't know what that might be yet. We'd have to look into that. But the initial argument, Linda, is you cannot change me in the current year to whatever this fair market value number you've calculated because you didn't do it right. That's where we would start with that, okay? And not everybody got a notice, because they're trying this bastardized quarter quad scenario of LaGrange Township, Shoal Creek, Burgess, and some part of Central, whatever. Those are the people that got notices. If you're in the other townships, you may have very well not got a notice. So what we're talking about doing now and bringing these legal arguments is only for Burgess, Shoal Creek, LaGrange, and part of Central. Okay, the other townships, what we're talking about doesn't apply. So if you think your taxes are too high, that's a different conversation, because we're talking about what's currently going on right now. Okay. And again, we're only talking about your right now for the notices you just got. If you didn't like what happened the year before and you paid your taxes, you're shit out of luck. Okay. That's once you pay the taxes, and if you didn't pay them under protest, you can't go backwards and try to fix something that you've already done. That's why it's very important that you take the time to understand these things. And again, I'm going to be as polite as I can when I say this. Don't just assume what their offices up there are telling you guys, because they don't really know what they're talking about. And they're trying to cover themselves because they've created a SHIT storm that's got them completely paralyzed. And I've got clients calling me saying, Tom, they lied. They didn't tell me this. They told me this. And what they said last night at this meeting was different than what they told me. What do I? And I'm like, just don't worry about that right now. But, I can't help the fact that I tried to stay out of this argument in Bond County, but it's gotten to the point that it's hurting the taxpayers of this county so bad, I can't just sit by anymore and say, I'm not going to try to do something about it. Otherwise, there's a lot of other counties that I can go to that I don't live in. But, this is my county. I live here my whole life. And I've always known there's been some problems, but I've tried to stay out of it. But now, I've got people calling me going, Tom, my taxes are going to triple. And I just can't sit by and do that. So if you want our help, that's fine. Fill out that link that Ryan sent you. We've got plenty of time. But again, you have to be one of them that got a notice in June. You're going to get a new one. And we've got time to deal with this. But, I don't want to wait too long to get this filed, a week or so maybe. So if you want us to help you with this, by all means, go on and do that. If you got any questions, email Ryan. I like doing it. We did that a lot in the last year or two. Email Ryan. But a lot of you know me too. And so if you know me and call me and text me, I'll do what I can to answer. But need to take care of this. The general inclination of taxpayers is to complain, get frustrated, go holler for 5 minutes, and then pay the bill and move on. And if you want to do that, that's okay. But again, the issue, especially the third one of notice, I've never seen anything like this in my career. It's just absolutely ridiculous to send these notices 7 months late. I'm highly confident we can win that argument. But again, I think it's going to take winning that argument in a courtroom to fix that. I don't see any set of facts under the sun that the assessor is going to, you go in there and try to argue what I've just given you. She's not going to change it, because if she does it for one of you, she's got to do it for everybody. You think she's going to do that willingly? I don't think so. It's going to take a huge court action to get that fixed. And if, again, and you file your own, get another lawyer, that's fine. I'm not advocating, but if you're not a part of some, filing under protest or paying under protest, or the proper way to bring this in front of the board of review, etc., if that doesn't get done right, you could lose the opportunity. And I don't want you to lose that opportunity. So if you want my help, great. If you're going to find another lawyer, that's great. If you want to try to figure it out yourself, that's great. But, don't just sit back and wait, because time is of the essence in the next 30 days. Okay. Let me see if there's any questions real quick, guys, before I go. Bob, you got new notices in Shoal Creek already? I'd like to see one of them. I didn't get mine yet. So if you got one, Bob, take a picture of it, send it to me on Messenger. Because again, I was told that those notices might go out today or tomorrow. So if you got them already, new ones, because the ones from June 23rd, Bob, are not the ones we're talking about. Whatever you got, shoot me a message. I'd like to see it. Let me see. Okay, I'll look into that, Nicole. She did part of LaGrange last year and part this year. And Nicole, why that's important is because you remember when I explained to you in the statute about how you break a county into quarter quads, where you have to specifically list in the resolution the county board, because only the county board has the authority to do this. Georgia doesn't have the authority. You have to list the assessment districts 1 through 4, because you break it into 4, and you have to list what townships are in those assessment districts. You know, the other part of that law says you can't break up townships. Township has to be a whole. So the fact that she's breaking up townships is problematic too, because she's doing it on her own. Georgia just went and said, I'm going to do this and break it all up, and because I have to do it. And again, Georgia, God love her. I understand she had some family tragedy back in 2020, and I'm not making light of that. But you know what? That's not an excuse to break the law and to violate people's rights of how their properties are assessed, because while her life was upset because of some family circumstances, you went and upset thousands of people's lives as a result. You can't do that. I'm sorry. I'm not being cold, but you can't do that. I'm sorry. Let me see. I don't think there's anything else. I think that's it, guys. Okay. I hope that gives you enough information. If you got any questions or anything, email Ryan. I'll try to answer them. If not, if you want us to help you, click on that link, get it filled out quickly, send it to your friends if they're interested, fill out quickly, or go find somebody to help you, or educate yourself pretty quick, because you don't want to miss out. And because if you miss out and you miss it this year and your taxes are going up 1,000, 2 or 3, and you don't get that fixed right now, that tax is going to get added on to you forever. So $1,000 issue could be a $30,000 issue. You don't want that, okay? Have a good night. Take care.